Next, from Chicago, we sit down with Christopher Hurley, the president of the Illinois Trial Lawyers Association, and talk about the types of cases a trial lawyer would take, why he says class action lawsuits are necessary, and the effect of workers' compensation on Illinois job growth. This runs about 50 minutes.
Chris Hurley, thanks for joining us on the Illinois Channel. You are currently this year the president of the Illinois Trial Lawyers Association, and with a number of issues being discussed by candidates and the governor, we thought we'd want to get together with you and kind of get your thoughts and the thoughts of the Trial Lawyers Association on some of these particular issues. Before we get into them specifically, tell for those who don't know, A, what are the trial lawyers? How does a trial lawyer differ from some other type of lawyer? And let's just start there.
Okay. Well, as a trial lawyer, I'm a person that represents usually individuals or human beings that are injured in some way or have in some way been harmed either by another person or a corporation. And it can be all kinds of different things. I mean, it can be car accidents or medical negligence or product liability or construction accidents, but it can also be business disputes and that kind of thing. So as a trial lawyer, I'm the guy that can go into court and make an argument for my client, and in my particular case, and for most of us, we represent people and not corporations.
And I guess the difference is a number of lawyers, depending upon their practice, might not ever go to argue a case in court.
That's actually true. It's a very small number of lawyers as a percentage that actually go in and try cases in court. You know, it's not a skill everyone has, and it's not you know, the type of work everybody enjoys. I happen to love it, and I think most of our members love this kind of work, and that's why we do it.
Does it take a particular kind of personality, or do you find that your comrades, their personalities just run the gamut?
Yeah, like anything, you can't overgeneralize, but it has to be somebody who is up for a good fight and doesn't back off. You know, when somebody needs a champion in court. So you have to have the guts to go in there and make arguments, and you have to have the willingness to take risks. And sometimes you win, and sometimes you lose, and you have to have the courage to face that.
How, again, we'll get into the issues, but I'm just still kind of curious. And I guess people would, you know, in a negative sense, when people often say, well, you know, I'll sue or this, that, and the other, your association or your branch of the law, you might say, that those lawyers who go into court are the people that will take someone's case and say, we're suing someone, or, you know, for, as you mentioned earlier, something that allegedly went wrong. Some mistake there, some injury, either physical or some other fashion, business injury, something that should not have happened in the way you would argue it.
Yeah, we're the guys that give the average person the ability to get his rights brought to court and decided, you know, according to the rules of due process by a judge and a jury. We're the guys that enable you to do that. You know, I worry sometimes because there's, you know, comedians or whatever make comments about suing and, you know, everybody's sue happy. I find that to be not anywhere near the reality that I live. We don't bring frivolous lawsuits. We only bring lawsuits that have merit, and there's a reason for that. Juries don't award money in frivolous cases, so I can't make a living representing people that don't deserve to be in court. So we're very careful to only bring cases that have merit, and that have merit both factually and legally.
Let me bring up what sometimes here and there we'll bring up what some of your critics would say. Now, critics might say, we would accept that you're not going to bring a case to court that doesn't have merit, but that, and I don't mean you as an individual, but that trial lawyers, they would say, often bring cases hoping that the person that they're threatening to sue will just settle and they can make a quick $10,000 or $20,000.
Yeah, that's not been my experience. So I've been doing this for 35 years, and it's not been my experience that you can get away with that. You know, look, if the case shouldn't settle, then it doesn't have to settle, and you can.
Isn't there a cost factor, though? I mean, I know a case where there was a bus hit a car on a snowy day when the car was, so, you know, who do we blame? Mother Nature, but someone who was on the bus said they were injured, and the insurance company for the car owner just paid them off, you know, like $10,000. That's you know, you hear some of these things where we've heard stories where on another case involving a bus where there were more victims than there were bus riders.
Yeah, these are anecdotal stories, and often you have to be careful of the source when you hear those stories. So make sure, first of all, you find out who's spreading that story. There's one that circulates on the internet. It's called the Stella Awards every year. Have you ever seen this, where I get this from my friends, or friends who are not lawyers all the time. They send me this internet piece where they report 10 incidents of crazy things, like a guy put his cat in the microwave and then sued the microwave company and got $1 million. Okay, obviously would be very upsetting if it was true. Mm-hmm. It's not true. So when you hear these anecdotal stories about people that got jackpot justice, first of all, consider the source, and second of all, find out if it's really true.
Well, sometimes it would be true, though, right? I mean, and we wouldn't say, let's say not $1 million settlement, but you get these where people will, okay, look, some corporation's going to pay. There was a Wall Street Journal article some years ago. A guy pulls over because they were taking the American flag down, and it was a big flag, kind of a windy day, and he held on to just be helpful. A gust of wind catches the flag, picks him up, and hurts his back. And a flag maker was named in the suit. He said, it wasn't even my flag. And they settled for $6,000. He said, if we'd gone to court, it would have cost you at least 10. So,
yeah, I'll tell you.
As an association, again, I want to make sure people understand, I'm not targeting you as an individual, but as a spokesman, to what extent, when we hear these, are they true? I mean, certainly there's some exaggerations, but are there problems along these lines that need to be cleaned up? Are there charlatans in the industry, whether or not they're members of your association, and if there are, is there any policing mechanism to try to say, when someone brings a suit, it's going to be for legitimate reasons, as you would represent, here's a client that's been injured in one form or another?
Sure. So there's good lawyers and there's bad lawyers. There's good doctors and bad doctors. There's good journalists and reporters, and there's bad ones, right? So that's true of every profession, and right. We do in the legal profession have a mechanism called the ARDC, where if the public feels that it's been treated unfairly or wrongly by a lawyer, it can be reported, and it is investigated in every single case, and it's thoroughly investigated. And if there's any merit to it, the ARDC will censure and punish the lawyer, and in some cases take away their license. So that happens on a regular basis. And it's unfortunate that those lawyers are out there, but we have a mechanism in place to police them. Now here's the second thing, though. Each case that's brought, is going to have a judge, and ultimately, if a jury is requested, will be decided by a jury. If the case is as frivolous as you say, and this flag case sounds very suspicious to me, so I can't even imagine filing a case against a flag manufacturer for those facts. But if somebody did that, there should be a judge who sits in that courtroom, and there's a procedure called summary judgment, where the defendant can bring a motion for summary judgment and say, Judge, I can't be sued for making a flag in these circumstances. And the judge in that case should throw that out. And there should not be a payment. And if some insurance company makes a business decision about paying frivolous suits, well, then shame on them. Don't pay frivolous suits. I don't believe in it. I don't file them. I don't think they should be paid. I don't think they should be brought. And most of the insurance companies I'm familiar with, the smart ones, don't pay on them, and they shouldn't.
Let's go to some of the issues that have been brought up. Governor Rauner has argued a number of things in an effort to turn around the state economy, and among those would be that he wants to get workers' compensation down. We just interviewed the head of the Illinois Manufacturers Association, Greg Bays, and one of his members. And they say that, the cost of an injury to an arm, that they're not trying to take away benefits from a worker, but that the cost of an injury to an arm in Illinois would be 50% more than it might be in a neighboring state. Now, maybe that's the fault of the medical society, I don't know. But the other thing, of course, is this issue of causation. And that if somebody is injured outside of work, but maybe some small percentage of the contributing factor was work-related, that the owner of the business, his workers' comp insurance, will have to pay for the entirety of the bill. And they're saying, if someone sprains their ankle playing softball on the weekend, and then later when they're carrying a box of books or something, the ankle gives way at the work site, we shouldn't have to pay for the whole cost of that because they were injured off the job predominantly. What say you about causation?
Well, you can't throw out a worker's case because he has a pre-existing condition which may have made him susceptible to an injury. And so, certainly there should be no cases where fraudulent claims are paid. And again, there's a procedure in place. There's a mediator, an arbitrator that is independent, who's required to make the decision and make sure there is causation related to the work. And those people should never, obviously if there's fraud, that should never be paid. And no one in our organization would ever want something like that.
Should there be a situation where, well, how is it now, just to make clear? Is it true that the business then would have to pay for the entire cost of that injury? And let's say, again, maybe I'm making something up, but maybe he injured his back playing softball, but then when he's moving furniture in his office, he throws his back out again.
Well,
to what extent does the business, first of all, the way it currently exists, does the business have to pay for all that?
Well, I mean, to the extent that the business and the work that they are having the worker do contributed to an injury, they should pay for it. Because what's the alternative going to be? This is a guy who might have a white
Jeff from that one, but because when you say they should pay for it, I think the question then is, do they pay 100%, or should they say, well, he injured his back, we knew he was injured his back playing softball, maybe he took a day off or 2 days off because his back was bad after the weekend? Should they have to pay 100% then? Or I think that's part of the argument of some of the, not just manufacturers, but business community, that they're saying, maybe we do 30%, but we're picking up the whole thing, and it really had nothing to do with our work environment or how well we managed the shop floor or how we had things marked on the floor and trying to be careful.
This is really an insidious argument by the Manufacturers Association
and businesses at large.
And whoever's making this argument, because here's the thing with the workers' comp system. It's a compromise system. And what that means is that if I lose my leg on the job, okay, if I'm a $15 an hour worker and my leg is lost due to your gross negligence as an employer, okay, I recover about, if I'm a $15 an hour employee, less than $100,000 for that injury, for the loss of my leg, okay? Now, that's a reduction in what that person could earn if they were able to go to court in the civil justice system and sue the employer for negligence, where I think a jury would easily award millions of dollars for an injury like that. So the employers are getting something for a system where the employee is guaranteed some recovery, okay? So rather than having to prove the negligence of the employer when an employee loses his leg, he gets an automatic payment of his medical bills, a portion of his lost wages and some small payment for the permanent injury that he suffered. The employer, in trade-off for getting the reduced payment for this obviously horrendous injury, has to pay anytime it happens at work. And so now employers are saying, well, we don't want to have to pay if some of it happened outside of the job.
But is that a legitimate argument to say if part of it happened outside of the job, why are we responsible for 100%?
Okay, well then fine. If they want to go back to a system where then the employee has to prove, what percentage happened on the job and off the job, perhaps the system should allow the employee to get more damages.
Do other states have such a system, or systems different than ours?
I'm not sure what all the different states do, but I can tell you that in our state, in the last 5 years, since reforms were pushed through in 2011, our costs are down and our rates should be coming down, but they aren't coming down because the insurance companies aren't lowering the premiums.
I was going to say, I think there was a study out of Utah about a year ago, and if I remember right, Illinois was approximate in the top 10 or so of, they listed all the states as far as the cost of workers' comp. I don't remember precisely. Let's just say Illinois was very near the top, in the top 10. The governor's saying, if we can make some reforms, and Greg Bass with the manufacturer said, we don't have to go down to compete with Indiana, which is almost at the bottom as far as the cost. But can we get to be where we're around 23, 25 of the states instead of, say, 9 or 10 as far as the cost? Because that puts us at such a competitive disadvantage. From the Trial Lawyers Association, have you entertained the idea of what reforms, if any, could be made or should be made from your perspective to bring that cost down?
I think the reforms that should be talked about would be insurance reforms. So, why do we have hundreds of companies that come to this state that want to write workers' compensation insurance? Are they doing that because they're not making money? I mean, there literally are hundreds of companies that write this insurance and are charging manufacturers and other employers for this insurance. Why are their premiums not coming down when we know costs have come down since 2011? So if we want to talk about reforms, let's talk about insurance reforms.
I started to ask, why do you say costs came down? The costs from the previous reform effort, you were saying, what cost?
In 2011, an insurance or workers' comp reform package was pushed through, which has resulted in our state being one of the better states in terms of decreasing costs for workers' compensation. And so, and now they want more.
Well, when you say one of the better states as far as bringing the cost down, but earlier you were mentioning that the costs really haven't come down much. You were blaming the insurance company for keeping it high. What costs have come down from,
Sure.
How do you measure that?
The National Council on Compensation Insurance advises that Illinois rates that should be cut by 13%, and they have not been cut. Medical payments.
And who is that group? Is that a
National Council on Compensation Insurance?
Okay, is that an insurance industry group?
I think it's an insurance. I'm not sure who it is, but I know it's a group that puts out information on insurance rates, and they've advised that the rates should be cut. We know medical payments are down 15% in our state since 2011. We know the average medical payment in Illinois is $14,000, while the average medical payment in Indiana is $18,000, Wisconsin $17,000, and Iowa $16,000. So there's been a 19% decrease in workers' comp benefits paid out since 2011. So, the industry just wants more, and they haven't really shown us why they should get it, number one. And number two, any discussion of reform needs to start with insurance reform.
Have you, as an association, typically the trial lawyers are a big supporter of the Democratic Party, Speaker Madigan, Have you reached out as an association to the governor's office and said, you know, let's sit down and given your views as to what should be done, and said, hey, take a look there at the insurance companies, because maybe that's where the problem lies?
So the governor, when he was running for election, held up a list of all the judges up for retention and just said vote no for every single one of them without regard to any of their qualifications or abilities. Just because I guess it's his view that the legal system doesn't work. It's quite clear that the governor doesn't want to have a dialogue with the trial lawyers. And you know, I'm sure I could call him, and I'm sure my call would go unanswered. But you know,
Because have you as an association reached out or made the effort?
we are always available to talk to the governor. And you know, if he wants to talk, I'll be there the next day to talk. But it's clear to us that he's already established in his mind what his agenda is, and his agenda is to make it cheaper to injure workers in Illinois by reducing the cost.
I think he would say that he wants to make it cheaper to insure the workers, right? I mean, to have just the cost of insurance come down,
Yeah.
which, whether it's, if it's, as you say, the insurance companies that need to just lower their rates based upon the level of incidence, have you
Well,
looked, or
wait,
has anyone-
hang on, let's go back to that. When the governor's agenda is to make it less expensive for companies to have workers' compensation,
Right.
that means it's going to be cheaper to have injured workers in Illinois. And here's what you'll get with that. You'll get more injured workers. That's his agenda. So be careful what you wish for. No, I'm sorry, go ahead.
I'm not going to argue. I mean, I'll try. I'm not arguing for him, but I would say I try to represent what I think the other side would say, so we can get your response, and we got that. The business owner we just said would say, look, it takes us. It's a long, hard task to get right the good workers. It's to find good people, and you want them to be productive. You don't want them to be injured. So no one wants someone to be injured. Aside from just the humanity of it, they would say it makes us less efficient if we're going through 12 to 20 people trying to find the one we're going to hire. When we find that person, we don't want them to be injured on the job. That's, you know, and that they're saying we're trying to do our bit to keep the workplace safe, but we just want to
Well, you know,
not
talk-
have our costs continue to increase.
Well, yeah, sure, but talk's, you know, cheap, Terry. It's really what you do when it happens. You know, when I say be careful what you wish for, I mean that sincerely. And I just, if it's okay, I'd like to go a little bit back in history just to remember how we got to where we are today. If you remember, I'm sure many of the viewers will remember the Triangle Shirtwaist factory fire in New York back in 1911. Okay, this was
So all the children were.
yeah, this was a case where young
Kind of a
girls,
sweatshop in New York City.
young girls were in a sweatshop on a 10th floor of a building in a factory, and the owner of the factory would lock the exits because he was afraid they would take unauthorized breaks, and he was afraid that they'd steal things on the way out, some buttons or whatever, so he'd lock them in. And so a fire breaks out on the 10th floor of this building, and the owner gets away, and the foreman escapes, but 146 young ladies died in the fire. Some of them, about a third of them, from having to jump out of the building. And so what?
With some extreme, I mean,
Well, no, but hang on.
You wouldn't argue that that's the case today, that workers or employers, generally speaking, are doing that kind of action.
You know, the argument that workers get too much when they're fairly compensated from an injury at the job has to keep in mind the system we came from, which is a system where it was totally slanted in favor of employers. And so where in that case, the triangle shirt case, the employer, upon being found guilty for wrongful death, only had to pay $75 per death in that case. And the insurance company paid him $400 per death because he lost time from work. So there's a situation we don't want to go back to. We want workers.
But no one's arguing that. No one's arguing that we go back.
No.
That we set the clock back entirely. And I want to move on to some other issues, but I think they were just saying we don't mind having a system. We don't mind having workers who get injured on the job being compensated and taken care of. We mind that in Illinois the cost is so high relative to other states for whatever reasons, and maybe they're pointing erroneously at the trial lawyers. I mean, you would argue it's not yours, it's the insurance. But I think as far as where employer groups would say is, we're trying to compete with the guys in Iowa, and Indiana, and St. Louis, Missouri, and et cetera, Kentucky, and all of those places. One, the cost is lower, and B, as a manufacturer, let's say, I have a fiduciary responsibility if it's a corporate-owned place instead of a sole proprietorship. I have a fiduciary responsibility, and if I can move 1,000 workers to a different state and save $1 million a year in workers' comp, I'm going to do that. In 10 years, it's $10 million, and that's so. The governor and others, I think that's the contention that they're saying. It's the cost structure of the insurance, not to not have insurance.
Look, it's a continuum, right? And
Right.
you know, your point's right. Nobody wants to go back to the turn of the century when life was cheap, and workers could be injured with impunity, and there'd be no consequence. We don't want to go back to that.
Right.
And we don't want a state where companies can't afford to work. But we do want a state where workers are treated with dignity and respect, and they have the right to work in a place that's safe, and it's not cheap to injure them. That's what we really want. So that falls in between, and I'd agree with you on that.
Let's we'll move off, but just to close out on this, but it's one of the major issues, so we want to spend some time on it. And we do hear the governor speaking a lot, so we appreciate you coming in to give the other side of the argument from your perspective. Of cases, whether your own, let's not just take your own, because any lawyer could have a different structure. What % of trial attorneys' cases, I don't know if you know this or not, are workers' comps? Is that a big part of the industry? Is it a minor part of the industry? How does it rate?
Well, in my particular case, we don't do much of it. We refer it out to other lawyers. There are, I think it's
Probably some people specialize perhaps in it or something. Or
there are definitely firms that specialize in it. As a percentage of our organization, for example, I think it's a fairly small percentage. It's probably 10%.
With trial lawyers, and let's just say, if we had a pie chart of all the different kinds of cases, and again, I'm thinking more of an industry because any lawyer might specialize in certain cases. What kind of things are there out there? What would be some of the big items within the industry where suits are being brought in this economy?
Well, it's that I don't know of
Would
any
it be medical? I
studies
mean,
on it.
is it a lot of medical? Is it I don't know. Do you take cases of fraud? I mean, we just look at this
Sure.
Wells Fargo case here. They
Yeah.
had a golden reputation, and it turns out
Yeah.
they were defrauding I don't know how many people.
Classic, yeah.
And that would almost be a class action lawsuit, would it not?
Yeah, potentially I would think it would be. I mean, so it's a perfect scenario for a class action. So let's just
And
tell
let's
everybody.
explain why that would be.
Yeah, so the Wells Fargo case, as I understand it, and I'm not a banker, but as I understand it, there were salespeople in the bank creating accounts for clients of the bank without their permission. So you're going along and everything's fine, and you're getting billed for accounts that you didn't want and you don't need. And it's probably a small amount per person.
Right.
Let's say they charge you $20 a month for this account. Some people might not even notice that until some time went by. The point is, when you do notice it, you're like, hey, I paid an extra $100 for accounts I don't need, and you call Wells Fargo. And it doesn't have to be just Wells Fargo. It could be any big corporation,
Right.
your cable company. You call them up and you say, hey, I want my $100 back, and they put you on hold, and they don't come back, right? So what's your choice then? You can then call the
Because
attorney.
the average person is not going to go to court
Over
over a
$100.
$20 a month bill or something.
Exactly. So you have a $100, $100 has been stolen from you. Now you call the Attorney General, and maybe if it's a big case like Wells Fargo, the Attorney General gets involved and they've sanctioned Wells Fargo. But if it's something less than that, the Attorney General might be too busy, so you get no help there. So then you call up a lawyer, and the lawyer says, well, okay, that's great. I'll take the case. I charge $250 an hour. And the client's like, well, I only lost $100, so there's nowhere to go there. So the only thing the law provides in a case like that is a class action mechanism. And that's where hundreds or even thousands of people can join together, and it makes it a big enough piece of litigation that you can afford to pay the lawyers, and it makes sense to bring it that way. And so without that, there's nothing to stop a company of that size from, doing really what they want.
I'll tell a personal story. You just reminded me. I got a postcard in the mail, and I almost threw it away thinking it was some phony baloney scheme. But I had an earlier version of an apple. And a little bit of liquid in my pocket from a mouthwash container leaked into this phone. And Apple would say, well, we don't guarantee it if the phone had any kind of liquid. Unbeknownst to me, there was a class action lawsuit, Brian. And I got $250 back for
Oh, is that
the
right?
phone.
Yeah.
So, I mean,
But I mean,
I thought it was unfair. So, I mean, there's a case where, and there was an argument made, again, I'm not arguing the governor's case. I guess I'm representing their case. I'll represent, in this case, perhaps the trial attorneys. To some extent, we had a panel discussion, which I believe I mentioned to you off camera before, but here at the Union League Club of Chicago. Are class action lawsuits a good thing or a bad thing? And one of the points made by those arguing for the class action were that there are not enough regulators in the government, nor do you want to have
right.
with the salaries, the pension benefits, the cost of having someone always on duty as a regulator.
Right.
You don't want to have people constantly looking over your shoulder. But there's not enough regulators to keep people honest, and so we have things that come out. Wells Fargo here, we'll let them argue their own case, but I mean, that's the kind of thing that can happen. And that the argument was the trial attorneys as an industry, you might say, are the hired legal guns that if someone takes advantage of people in some form or fashion, that you're the ones that would go to court to represent them and keep the system honest.
Yeah.
Is that more or less the case to be made for the industry?
You couldn't have said it better than I could have. I mean, it is the only thing that stands between us and really the domination of our legal system and society by people with money. So, people that don't have as much money need access to the courthouse, and we need to be able to police these corporations and moneyed interests. Now, sometimes it's just, some corporate people that have, run amok. And sometimes it's, what's the Volkswagen case, right? Where they deliberately falsified the air quality.
Air quality. They didn't want their cars were not complying with the EPA standards, so they falsified the reports to say that the cars were matching the EPA standards.
And so it's the instant that comes
and
out.
And again, another major corporation with a good name.
Right. And the instant that comes out, the value of the car you bought plummets, right? Because everybody knows it's a fraud. And so if lawyers can't get involved to bring a corporation like that to heel, the rest of us have no chance.
We have right now, as we sit here, the Samsung case with their phones, their batteries. Now that would be a case, I would guess, I'm going to presume, because it doesn't seem like it would have been in their interest to have put out phones that they knew were going to be catching fire and exploding, etc. On the other hand, there's going to be some people who are injured.
Right.
Who are going to, their leg is burned, or maybe their house burnt down, their car burns down. There's one example where a car caught fire because of the phone. So what's the real answer in a situation like that? I mean, in other words, if you have in this case, a manufacturer who wasn't purposely trying to put out a bad product, but the product was, on the other hand, bad. It was faulty, and it did cause some damage. What's the response of the industry to something like that?
Oh, I think the immediate response is recall the dangerous product. And what you'll see them do sometimes is they wait to recall it. And that's really where the problem comes in. So we've seen that with the General Motors cases where the car would get stuck in drive and you couldn't get it out of drive and people were being killed, and they delayed the recall. Or the Ford, the most, an interesting example is the Ford Pinto case. You remember that case? This is back when Ford knew that with a relatively small rear end impact, the Pinto would burst into
in flames, yeah, because the gas tank would explode, and that I figured it was maybe a $50, maybe not even that much cost. But
so they recognized that was happening, and they recognized that they should recall it, but they also recognized that it was cheaper to pay the wrongful death claims than it was to recall the products. And that's where the problem comes in. As soon as they discover the safety problem, they need to recall it immediately. Now, I don't know how long Samsung has known that their phones burst on fire, but presumably the second they found that out, they need to recall all of those. If they don't, and people are injured because they made a calculation that it's cheaper to pay the claims than it is to recall the phones, then that's the kind of thing a trial lawyer needs to show to the world and make an example of them on.
You know, one of the, it's funny, we just talked about Samsung, we talked about Wells Fargo, we talked about Volkswagen, you mentioned Ford. There are these instances, and we don't want to say all corporations are bad. As you say, sometimes it might be a lower middle management guy who's trying to cut costs to make himself look good. You never know where the costs. I don't want to leave people with the impression that corporations are out to take advantage purposely. Sometimes I think, like in the Samsung, I will presume that it was a faulty design and they just weren't aware that these batteries were as bad. One of the big cases that came out not too long ago, and it was in St. Louis, I think maybe a year or 2 years ago, a woman had been using talcum powder by Johnson & Johnson, another great name, great corporation, been around for over 100 years. And a lot of people have used it. I guess it's the equivalent of baby powder is what I would imagine.
I believe that's what it is, yeah.
And so all kinds of people have used it and used it for years. Now, her family, because she died of cancer, are saying it was caused by the talcum, and I think they got a $72 million judgment, if I remember. And we see the commercials from that. This is where I think some people look at that and they think, trial attorneys across America smell blood in the water. And so now we're running the ads and bring us your cases because we've got this. What would you say to those people that make that kind of a statement?
Well, I mean, so if the statement is that trial lawyers are bad because they want to help people get justice, I honestly don't understand how I can respond to that. I mean, here's the thing. If Johnson & Johnson knew, and I don't know, I don't have any of those cases currently, but if Johnson & Johnson knew that its product was causing cancer in consumers and chose to sell it anyway, why does it matter if a lawyer might get paid by bringing a case like that? That kind of conduct cannot be allowed to stand. Those people, if they knew, I mean, it's like the asbestos industry knew since the 1940s that asbestos caused mesothelioma and other serious, awful cancers, and they chose to sell it anyway because it made them, it helped them reach their corporate goals and their money goals. That cannot be allowed. And to suggest that because a lawyer who spends his career and many hundreds of hours working to fight for justice for those people also gets paid, that for some reason is that's somehow a reason that the case doesn't have merit, that doesn't make sense to me.
Let's speaking of asbestos cases, one of the arguments made by groups, and we recently interviewed, I think, or not interviewed, but aired comments again made here at the Union League Club from the Illinois Civil Justice League, that the case of venue shopping, that the lawyers are gaming the system by bringing cases, filing cases in venues where they know they're going to have a sympathetic audience as compared to maybe the specific incident of where it happened. And so they often cite Madison County, Illinois, where a great preponderance, their argument is, of cases, and I don't remember what the number they use, of asbestos are brought. On the issue of venue shopping, but
it's another interesting question. So you have a judge who's responsible for making sure that venue is proper in our state when somebody brings a lawsuit. And venue is proper if the corporation has an office or does business, or is a corporation that has a headquarters in our state. So that judges it's fairly simple for the judge to screen for that. If venue's proper under our laws, then there's another way the court can dismiss the case and send it elsewhere. It's called forum nonconveniens, and that requires the defendant to bring a motion saying, hey, this is not a convenient place for this case to be because all the witnesses are in Louisiana. Okay? If the defendant doesn't make that motion because the defendant would rather have it in Illinois, then who's complaining?
Why are so many cases heard? I'm presuming that that statement is accurate. Why are so many cases heard in Madison County?
Well, I think it has to do with the fact that some of the lawyers that are specializing in that practice have offices there. It probably also has to do with the fact that the defendants don't want to have to travel across the whole country to litigate all of their cases. Now, let's say you're a corporation that has 300 cases against you that involve asbestos injuries. You may not want to go to 50 different states to try those. You may prefer to have them all in one place. But to then go and say the system's broken because both sides want to be in Madison County doesn't make sense to me.
When we have a case, and I think with the talcum powder, there's now a settlement fund set up. How does that work? I mean, here typically you would be arguing, trying to win your case, and if you get it, you get a settlement. But when a settlement fund is set up from some, whether it's asbestos or the talcum powder, can any lawyer then just find a client and bring them in and get some money from that settlement? Or is there some filtering process of, who can have a case that would be applied to that fund?
Well, yeah, so we have to be careful what we're talking about. I don't know of any massive fund set up for talcum powder at this point.
I may be wrong.
That may be
well,
something.
Let's use the asbestos. I believe they did that.
Yeah, and that's somewhat complex because there's many different defendants and many different types of plaintiffs. But I would say that what's happened in the past, if there's a bankruptcy, for example, the bankrupt corporation creates a fund, and let's say there's $1 billion in the fund, and then people that are victims of the product that they sold can then appeal to the fund and say, yeah, I was exposed to this product, I have this disease, I can prove it, these are my doctor's reports, here's my evidence, and then the administrator of the fund will pay out the claims according to however that's been agreed to.
And before we close out, let's talk about one of the things. Now, I grew up in Missouri. We have judges who are appointed. Here, judges run for office.
Yeah.
And the court system, should be viewed as nonpartisan. I mean, they're the referees or the umpires, you might say, of the legal system. What are your thoughts on, should we go to a different system instead of electing? And of late, and by late I mean maybe over the last 20 years it seems like, the cost of running for the Illinois Supreme Court has really exploded, with the trial lawyers putting in a lot of money, with other people who would oppose positions as an association, whether it's the business community, let's say, putting in a lot of money to support their candidate. What do you make of the system? I mean, and what about the taint that it might leave for a lot of Illinois citizens that go, is justice for hire?
Boy, it's a really interesting and complicated question, and if we can do a whole nother show on that.
Yeah, you can probably spend an hour.
So the first thing I'd say is, you know, there's some famous politician once said, I'm in favor of a system of appointing judges as long as I get to do all the appointments, right? So that's the problem with an appointed system, that unless we all figure out who's going to do the appointing, everybody worries
Well, it
that
would be
it
the
won't be
governor.
fair.
I mean, typically, if we went with the Missouri model, a lot of people looked at the Missouri model.
Yeah.
The trial, typically the trial bar, would say, here are 8 candidates for a position or 4 candidates for a position. We find them all to be qualified, and then governor can.
And he
I
has
mean,
to pick from that
can,
list?
He can pick from that list, or he could actually say, which the governor of Tennessee did a couple of years ago, say, you know, I'm not picking any of these guys. I don't like any of them.
So that's what you worry about,
Bring
though,
me
right?
back a new list. But at least in that case, the governor, just like the president, of course, the presidential campaign is we're having right now happening. I mean, one of the main arguments is, but who's going to be appointing the judges to the Supreme Court? So it works that way at the federal level. I mean, the president appoints. Should we have a system, in your estimation, where the governor's appointing, and maybe again where it's filtered through some of the legal community to say, here's some candidates?
So there's
And
really,
if not, what's good about the current system?
okay, the problem with an appointed system is who's doing the appointing. And so there's always going to be issues with a particular interest group controlling the appointments, and that's a problem. If it can be solved, and if Missouri solved it, I don't know. What's good about electing judges, and not everything's good. I mean, some elected judges are not as good as others. But what's good about it is that everybody, without regard to whether they're an African American or a female or some other minority group, has a shot to get in and get elected. You know, if for whatever reason the person appointing chooses only to appoint white men, we have a judiciary that's not representative of our community, and it wouldn't be fair. So the elective process allows everybody to get a shot at getting into those positions. I don't think there's a perfect system. You're going to have judges that maybe aren't as good that are appointed. You may have some that aren't as good elected. You have some great elected judges. I mean, I have nothing but respect for our judiciary in this state, and I think the system works well. Find me a perfect system. I don't know if there is one.
Before we close out, let me just give you the opportunity to make a summary, which, yes, as an attorney, you're certainly familiar with doing. Let's just summarize. What would you say are the for all the criticisms that people point to the Illinois trial lawyers, what would you say in general to say, here is the reality of our association?
Well, you know, I guess some of one of the criticisms I've heard is that we donate money to politicians, and then I look at a situation where our Governor Rauner, is a billionaire who has put 20 million of his dollars into giving money to politicians. So he wants a system where we are not allowed to give money to politicians, but only he is. And I'm not okay with that. You know, frankly, no one would be happier than if money was completely out of politics as far as I'm concerned, and if it was publicly funded elections. But until we get to that, you know, you can't allow one side to give their billions of dollars to public officials while the other side has no chance at all. And let me make this point: the trial lawyers will never be able to come anywhere close to matching the money that Governor Rauner and his friends have to give to Illinois politicians.
All right, well, Chris Hurley, we appreciate you taking the time to explain these policy positions, and best of luck to you.
Thank you. Thanks for having me. It was fun.